And welcome back, everyone. Along with Dominic, we bring in our good friend Jimmy Kasouris, and Jimmy usually is in a nice, comfy studio. I'm having you brave the elements today. All right, behind us, the Thurgood Marshall Courthouse, where Dom's been every day. Were you surprised Monday, not only guilty, but guilty on all counts here? The Silver team, you would think, would be a little surprised. Otherwise, why wouldn't they put a defense on? I was a little bit surprised.
I was surprised not only with the guilty on all counts, as you know, we've talked about it for a while, how I felt about the first transaction, but I was also rather surprised with the swiftness of the verdict.
And Dom mentioned there was one juror, and there was a question. She said later on she felt pressured. Nonetheless, if there was going to be an element for a retrial, of course, we've heard from Mr. Molo, the counsel for Silver, that they're going to obviously try and have a retrial. Is it on jury instructions by the judge? Is it on that juror that we mentioned? I've heard other people even say, we discussed this last night, that potentially that maybe Pripahara went outside the four corners before the trial even began. Do they have any grounds for an appeal?
Well, I do think they have grounds for an appeal. You mentioned why they didn't put on a defense, and I think the reason for that is they were resting on the record. I think they did, in many ways, try this case towards the Second Circuit. I think they will very much focus on the jury instructions and what the elements and what needed to be proven in terms of the quid pro quo was. And putting on a defense or putting Shelley Silver on the stand would have made that a little bit more difficult. As far as the pretrial publicity that was litigated, as you know, with a motion to dismiss, that'll certainly be grounds for one of the grounds for the appeal. As for the juror, unless something explosive comes out in terms of significant juror misconduct in the jury room, it is not unusual for jurors to feel pressured and for them to communicate that to the court.
And in fact, she said it was only a few jurors, as she said to you, Dominic, after the trial.
Yes.
For me, we talked beforehand. Whatever you think of Shelley Silver, the man knew how to navigate for 40 years Albany, and he knew where all the bodies were buried. I mean, that was part of the criticism against him with the late Vito Lopez and other cases here where he helped maneuver behind the scenes. We all said, first from the witness list he put forward, and then where all the other bodies were buried, we thought either he was going to flip on some folks. Apparently he turned down a plea deal, the terms of which we don't know yet. He didn't give anything up. Potentially he might. Weren't you surprised by that?
Well, Richard, here's one thing I want to focus on, and you made this assessment early on, and I wasn't really sure about this, but you were 1,000% correct.
Brilliant, Jim. Brilliant.
As always.
When you made the point that Albany was on trial. And, Counselor, when you talk about the quickness of the jury decision, which could have only been hours if not for juror number 6 holding out,
right.
Your point, Richard, about Albany, I think these folks were thinking about Thanksgiving.
Yep.
And they wanted this over and done with. And while there was no established or witness that testified directly to a quid pro quo, your point about corruption in Albany being on trial, that's exactly what happened here.
In fact, could the defense have said, you know what, we don't want a jury trial? Could they have gone strictly to the judge? They present the cases and have the judge make the call. And in retrospect, given the antipathy that the public has towards Albany, and you can say politics in general, Monday morning quarterbacking, would that have been a smarter move?
No.
Really?
No. To waive a jury and do a bench trial in federal court, first of all, you need consent of all parties. But no, that would not have been. You much rather get 12 in the box and hope that you have 1, 2, or 3 of them that are going to be on your side, and then hopefully spur a discussion that'll either hang the jury or move them in your favor.
Okay. We mentioned before, if anything, Shelley Silver knows not only how the gears work in Albany, but he did a lot of favors for a lot of people. We saw his witness list, among others that could have been called as witnesses, the governor, etc. I know that was typical posturing. However, if he does have any cards to play, and I don't say that he does, but he can flip on other people, even if it's 4 or 5 of his, well, now former colleagues, how could that mitigate the sentence that could come down? I spoke to people, sentencing experts. The guy's in his 70s. He's probably looking at somewhere around 20 years. Is that a card he can still play before they send down the term?
Absolutely. In federal court, if you cooperate prior to your sentence, you're hoping to qualify for a letter pursuant to 5K 1.1. You have 1 year after your sentence to qualify with cooperation for a Rule 35. So if he does elect to cooperate and give people up, he can certainly get a benefit. And what that does, it puts the entire sentencing discretion within the court, which is there now. But with that kind of emotion, a judge is told by the government he's done substantial assistance. We think you should give him less than what the guidelines call for. So he could definitely benefit himself.
But you would have counseled, if he was your client, if you have anything and you want to basically work a plea out, do it before the jury comes back, right?
Well, if you're going to cooperate, every lawyer has the obligation to present a client with all of their opportunities, which means prior to trial, you look at the client and you say, one opportunity you have is to cooperate. This is what you need to do. It needs to be full and complete and truthful. You have to give everything up, and you have to plead to everything you've done, and you present that opportunity and see if your client wants it.
Okay, finally, from the man that was in the room and also the former prosecutors on both sides of the aisle, the moment where the case turned, and for me, Dom, when Talbot was the star witness, the doctor at the clinic here who got the $500,000 of taxpayer money and in effect funneled the clients or directed them at least to the law firm, I thought under cross when he said there was no quid pro quo. I said, prosecutors got a problem here. Obviously, I was wrong. Did you get a sense, even looking in the jury box, it didn't matter who they did? Like I said, Albany was on trial, and he didn't really have a card to play. So,
Richard, good point. I really believe that Mr. Silver didn't have much of a shot in terms of looking at this jury day in and day out. It was almost like politics in a courtroom. And unless you're an insider to this game, it's very hard to comprehend. And so all they saw was the referrals that went to Whites and Luxembourg, the law firm. Mr. Silver didn't have much of a shot, right? And Glenwood didn't have much of a shot.
Well, but understand as well, we've said this before on the show. So often it turns on the jury instructions. And that's the key.
Judge
because
Caproni.
It may be that those jurors, and by the way, you look at it, I've been looking at them for 29 years, and reading the tea leaves is a fool's errand. But they may have been struck by that testimony. But once they got the jury instructions and essentially were told that you don't necessarily need to connect the dots that strongly as long as they can prove the conduct and prove what they believed Shelley Silver's intent was in giving that money, then they didn't need that testimony. And that's what this case is about, and that's what this appeal is about.
And finally, if I could, probably the only guy other than Silver and his legal team who had a worse day was, I got to think, the Skelos team. Because, if you think that Silver had a bad case, it's looking even worse for Skelos. You couple that with what every juror on that case has heard that Shelley Silver's going away. It's not looking good at all for him, is it?
Well, certainly what you read about the evidence that's being elicited, it doesn't look good. But we were talking before and chuckling about it. Wait for the verdict. You never know,
I would take the over in terms of him.
It's not looking good. But Richard, the point that you two have made about intent from Judge Caproni, I couldn't agree more. He had a chance, Mr. Silver, but when she gave that jury instruction and said it doesn't matter or connecting the dots, just deal with Mr. Silver's intent, it was a done deal.
And that's what the Second Circuit is going to be asked to talk about, to decide. Absolutely.
Jimmy, as always, my friend, thank you very much. I promise next time we'll give you a nice, warm, comfy studio. Okay. When we come back, Dom and I are going to be talking to a leading political reporter to talk about what happened behind us and what that means for Albany going forward. Business as usual, or could major changes lie ahead? Stay with us.